because when they happen, they are the sort of things that keep you awake at night. They're very stressful, plays on your mind. I would avoid email in terms of plugging AI into email at this stage. If you're going to do it, really, really risk assess it. Okay, if I'm going to use AI to give to the client and the client wants the IP, I'm going to have to say to the client, you can't have the IP because I'm going to use AI. If you want to have the IP, can't really use AI to give you a copper bottom guarantee that you will actually own this creative asset.
Ian and I were having a chat about legal stuff and AI, and the stuff that Ryan was speaking about, I had no idea about. I had no idea about at all. And that felt to me like quite a threatening position, for want of a better phrase. So we thought that we'd schedule this in as an opportunity for us as the community to learn about AI and what marketers need to know about the legal side of what we do and how we use it. Before we get going, I just want to say a big thank you to our sponsors. This week's feature sponsor is Frontify. They're a wonderful company who bring in together all of your brand assets into a single space. So if you've ever known that problem as a marketer, where you are getting people not using the right brand assets, then Frontify is your solution. Also, a big thank you to our other sponsors. We have Wistia, we have Cambridge Marketing College, we have Known, and we have Planable. Every one of them are fantastic companies that are here to help marketers do their job better. And so with all that said, that introduction done, then joining me on screen is the very, very fantastic, very lovely, very competent Ryan Lisk. Dude, thank you for taking the time.
My pleasure. Hello, Joe, and hello, everyone that's watching. Thank you very much for inviting me on today.
No worries, mate. I mean, like, I think we're going to have fun, which, as I said, is the opposite of what I usually think about law stuff. But you're right. You are. I really like you, and I think I know that you've come to help folks today.
Oh, thank you. I'll pay you later, Joe.
So let's get started. The first thing we wanted to do was speak to some examples, because this was the stuff that I mentioned in the introduction surprised me. And we've got 3 examples to speak through today. So I thought I'm just going to prompt them up for you here and cue in your storytelling skills, because the first one was all about Nano Banana and a photographer. So tell me more.
Yes. Yeah, no, the angry photographer and Nano Banana. What on earth could that be? But before I go on to tell the story, what I will say is I am anonymizing clients here, obviously to protect confidentiality. But the heart of the story is completely true, and it will hopefully help the audience understand how easy it is to sleepwalk into legal issues, but most importantly, how easy it is to avoid those legal issues once you know how. And I think when you've got context based on real life examples, it just helps bring it to life a bit more. So I just thought I'd preface that. So to answer your point around what happened with the angry photographer and Nano Banana, if I take you back to how the story started. So an agency was looking after a brand within the supplements industry. So if you think about like protein or tablets such as like ashwagandha tablets and various other healthcare products that are in vogue at the moment, they have an account for this particular business. And one of the gigs was to do a photo shoot for the new release of the product packaging that this particular brand has just recently unveiled. And they used their photographer that they've used for many years to go and do a day's worth of photography for the brand. And that was all really good, really exciting, seemed to go well, until a few months later, the agency that had that gig essentially received a letter from their photographer's legal team to say that they had used the photographer's images outside of the agreed scope of the project, and that was a complete infringement on the photographer's rights, because not only had they used it outside of scope, they had modified the images without permission. And essentially what happened was the agency had taken the photographs from that photographer from that day's worth of photo shoot and popped them into Nano Banana to create different backgrounds very quickly, very effectively. So it might have been a a box of tablets on a beach with a sausage dog and a sombrero, for example, like different contexts. And of course, the photographer clearly was very excited to see their hard work play out in social media campaigns and in various other formats of advertising. And they were horrified to see that part of their photography had been used way out of the original scope, hence what precipitated the need for lawyers to get involved. And of course, the agency thought, well, that's not fair. We can do what we like. We paid that photographer for that gig, and we've delivered to the brand that we're looking after, who are chuffed to nuts with what we've done with Nano Banana. Don't really see what the issue is. And the issue boiled down to the fundamental point that that photographer was not on payroll. They weren't an employee of the agency. They were a third party contractor. And as a result, because they're a third party contractor, they will own the intellectual property rights in the photography. So in this case, the copyright, unless there is a contract in place that makes it very clear that they will assign over the rights once that particular agency has paid the bill. So that agency could have paid millions and millions for that photograph. And if there was no contract in place dealing with IP ownership, the photographer's still going to own the photography. So that was the learning curve, and a harsh learning curve for that particular agency. And the plot thickened because where the plot thickens, and this is again another way of sleepwalking into legal issues, the contract that they had in place with the brand, which was on the brand's T's and C's rather than the agency's T's and C's, that contract made it very clear that any creative work that that agency delivers to the brand will be owned by the brand once they've settled the agency's invoices in full. So, of course, they're saying to the agency that they can have IP that they never owned in the first place because they've got this massive loose end over here. They've not only dealt with IP, but they've also put it into AI, which has now swallowed up that particular photograph and used now in a way that's highly likely to have trained the model. So parts of that photographer's IP is now appearing in other users' outputs, as is the nature of AI in quite a lot of cases. So that's a really quick way to sleepwalk into a litter of legal issues. So if we take a step back and look at how we actually unpick that, in fact, before I do that, does that all make sense so far?
Yeah, so we've got three sets of people here. We've got a photographer, we've got the agency, and we've got a client. Photographer taking the photos, handed it over to the agency. Agency's modified it in AI without the IP signed in the contract, and then the client has said in that we actually own the IP once you produce it for us.
Right. Yeah. So those are the issues. And what would have, in hindsight, the beauty of that lovely thing called hindsight would have been a conversation up front with the photographer to say, right, we need to deal with how IP works and what the price will be for us to own the intellectual property rights, in particular copyright, in the photography. Once we've paid you, we want to make sure that we own that. So you have a clear contract in place which deals with that aspect. And then the next aspect is looking at, okay, my client clearly wants to own the IP in the creative work. Should I be using AI for creative assets when I know that actually with third-party AI, it's very difficult to claim any form of IP ownership on the outputs because of the way these models have been built, the way that they've been trained. And you only need to see the number of different claims around the world at the moment, Anthropic being one of the recent big ones, along with Reddit against Perplexity, OpenAI, so on and so forth. All of them have got seriously high value claims at stake because of the problem with using other people's IP without permission. And that's then creating outputs for people that are led to believe they'll own it, but actually they won't, because it's not going to be completely unique to that user. So the agency has got to address that problem as well around, okay, if I'm going to use AI to give to the client and the client wants the IP, I'm going to have to say to the client, you can't have the IP because I'm going to use AI. If you want to have the IP, can't really use AI to give you a copper bottom guarantee that you will actually own this creative asset. can't really do that at the moment with AI. You need to do it the old school way, which in my opinion is the best way if you do want to prove IP ownership to your client. So that's how I'd unpick it. Essentially, thinking about, contract with your freelancer, contract with your client, and being very aware of the issues around IP ownership when you use AI. So that's like a very quick summary.
Love that. And so I can see already in the Q&A that we've got 4 open questions in the first sort of 5-10 minutes of you speaking.
Wow.
So like there's going to be questions coming in. The first thing I want to do is in us speaking about this webinar, like I wanted to be careful almost to protect you to a certain extent, because the context for us coming in today is like it's sharing. In fact, I'm not gonna put words in your mouth because
No,
I'm
that's
be
okay.
careful there. But how do we speak about the words which you're speaking about today in terms of advice, not advice, etc., etc.? How do we navigate this?
I would say probably the best bet is look, don't sue me if you go and use what you hear on today's webinar and it all goes wrong for you. Always take your own professional advice. There are lots of lovely law firms out there, cough and a nudge. But nevertheless, look, this is just really to raise awareness. I see this as an awareness piece. Hopefully, those that are listening, it will give them some food for thought when they're using AI, and also generally when they're working within their teams.
Mhm.
They know what type of things to look at, or stories of where other businesses have struggled, because it's really frustrating as advisors to see well-meaning businesses fall foul of contractual issues or
Mhm.
IP issues that could have easily have been avoided with the right advice. Because
Yeah.
when they happen, they are the sort of things that keep you awake at night. They're very stressful, it plays on your mind. So if I can help in any way by helping people avoid those, then great. My
Love
job is done. But yeah, my point is, yeah, please don't shoot me if it all goes wrong.
Love that, mate. Well, thank you for speaking to that, and it felt important as part of this. Looping back to your first answer, and when you're speaking about the unpicking of this particular situation, you spoke about there was the contractual stuff with the respective folks, but then you also said you almost placed a dichotomy between like you can't offer that copper bottom guarantee that if you're using AI, then that IP can be passed over to folks. So I guess my question is, in terms of solving this IP challenge, um, is it about specific language in the contract? And then on the second part of the thing where you're saying you can't do copper bottom, are we saying that you can't use AI, or somewhere in the contract you're just going to say we can't guarantee that IP is going to be passed over, if that makes sense?
Yeah, so I think when it comes to IP, I think it's worth, every marketeer really having a really good, clear understanding of the different types of intellectual property rights out there, including trademarks, copyright, patents, design rights,
Mhm.
understanding those four, and also you have database rights as well.
Okay.
So I think, it's definitely worth genning up on those areas and understanding the differences, because I think that's just general helpful knowledge in this day and age, and it's only going to get bigger now. But in terms of the whole copper bottom piece, does it need to be in writing?
Mhm.
Well, essentially, when you're using freelancers, when you're using contractors for creative work, because they are not on the payroll,
Mhm.
you have something called the Employers' Rights Act, which has a provision in there which essentially says that if you are an employee of a business and that particular employee creates something during their normal duties of employment, the employer will own any intellectual property that employee creates. Obviously, if the employee is doing a side hustle where it's outside of normal working hours and it's not within the scope of their day-to-day duties of employment, then there's a clear argument there that it's separate and that will be the employee's IP outside of business. It's
Right.
quite a hotly disputed one at the moment where we have a world where quite a lot of employees will have side hustles, and some
Hmm.
employers will think, "Oh, actually, I'd like a bit of that." And
Hmm.
actually, what you've come up with there, I think that was on my time. Actually, I would like to assert some ownership there. So that's uh, that's a whole different thread that we could go down. But keeping to your questions, um, when you're dealing with contractors that are creating IP for you, make sure you get it in writing that they assign you the rights, because there's a difference between assignment and a license. A
Okay.
license doesn't give you ownership, assignment does.
Nice.
So that simple word of assign is what you want to see,
Hmm.
and there needs to be a price exchanged for that assignment, whether regardless whether it's a pound or a million or beyond.
Yeah.
There needs to be some consideration there. So it's making sure that you get the wording right in the contract. And again,
Hmm.
you have things such as moral rights as well, where you could have somebody that still clings on to the ability to be named and attributed
Hmm.
whenever their work appears. So again, it's in fact we've got somebody here. Copyright is everything. Excellent from Morag. I agree with you, Morag. Copyright, very, very important right to be aware of. But again, it's having, I think, as marketeers, having a good understanding of copyright law is key, and just making
Hmm.
sure that your eyes are wide open when you're dealing with third parties that are going to be creating content or imagery, any form of IP. Just really be hot on that area, because that's really where it can unpick later on and create headaches for businesses. You see it during due diligence when an investor gets involved or when the business is looking to
Hmm.
sell. That's usually when the skeletons come out of the closet with IP issues.
Right.
So that's the whole importance around contracts and making sure that you have it in writing and particular wording that needs to be used, with the whole piece around where you can't really give a copper bottom guarantee that you own the IP that has come from a form of generative AI. The
Hmm.
issue that we have there is we're not in a world yet where you can stand behind the creative output of generative AI and hand on heart say that that is completely unique and it
Hmm.
will not appear in another user's output somewhere else around the world. There is no third party large language model that I personally believe can offer that at the moment, unless they have a very, very clearly defined training set where they have
Hmm.
all of the appropriate licenses, which is essentially said, do what you like with my IP. You know, you're paying us handsomely for it. Here it is, do what you like, swallow it up in your model. Only at that point, maybe, can you rely on outputs? But if you look at the number of claims that are still going on around the world, and also the fact that our legal system is still trying to fathom out what is going on with IP ownership that derives from AI. I would
Hmm.
say at the moment it's too high risk to rely on it. If you do want to rely on it, because let's face it, it's a tough economy at the moment. Clients are demanding more for less, and
Hmm.
AI is obviously a great way of cost effectively delivering work. I think what you do there is you be transparent with your client to say, look, we can do it at this price point using AI, but be aware of the risks. And that's where your contract really needs to protect you around AI use, making sure that you've made your client aware that you're using it, but understand that the client accepts that it's their risk, not
Hmm.
yours. And if they would like a risk free arrangement where the agency can guarantee the IP and the creative outputs, then they'll have to do it away from AI. And obviously, there's a cost implication in that regard, which personally I think that's a potential competitive advantage for some agencies that
Hmm.
can guarantee IP
Nice.
ownership. In a world where everyone's racing to use AI. So yeah, I can tell you about an interesting case that made its way all the way up to the Supreme Court around whether AI can own a patent, but I'll be guided by you, Joe. I don't want to go off down a garden path, but it is quite an
Well, no,
interesting case.
I'd love that, and maybe I feel like this is the type of thing that we need to pick up with you afterwards as well, maybe for the newsletter as well, because I think that would be a great example to pop in there. So, I'm aware that we've got three main areas that we want to cover
Of
off in,
course.
and then already 9 open questions from the community as well. So let me
Wow.
ask two questions from the community before we move on to the next example. So the first question comes from Deborah, and it's actually not specifically about this story, but I think it is a really good question nonetheless, which is one question I thought of as soon as I saw the webinar topic. What are the best resources for non-experts to stay up to date on the law? So AI, content, or tech related, as it's constantly going to be changing. I mean, this is fabulous today, but I guess in 6 months, would need to do it again. So do you have any resource recommendations?
Am I allowed to do a shameless self plug on that, which
Hey.
means it's no sales pitch? I promise it's not a sales pitch, but I do have a mailing list called the Legal Loop. I
Mm-hmm.
don't do any sales pitching. It's just sharing legal insights and tips
Mm-hmm.
with the hope that one day you might remember us and think, oh, yeah, we'll go and use hybrid legal. But of course, no pressure. But the relevance there is we do update our mailing list, our audience, on when there's a change with AI legislation or when there's a particular case that we think will be of interest to our business community. So you can sign up to the Legal Loop on our website, hybridlegal.co.uk. You'll find it on there. There is a sign up link on there. But otherwise, in terms of other resource, I mean, we have a subscription to Thomson Reuters and Bloomberg, so we get regular legal updates from Bloomberg and Reuters on what's going on with AI and the law. So those are two really good sources for us. Other areas that I would be looking. LinkedIn, obviously, there are some good commentators on LinkedIn. What I can do actually, Joe, is I can put together a list of key kind of resource points for you to follow up with the audience on, rather than me sit here and think about all the different things.
That'd be
Let
fab.
me take it offline. I'll think of a list of key areas that your audience can, engage with to keep up to date, and hopefully, that helps. So, but thank you for your question, Deborah.
You're a lovely man. You're a lovely man, and we'll pop that in Hive as well, as a place to head to afterwards. Let's take the next one from Caitlin, and then we'll move on to the next story, Ryan. But you're doing great, mate. So thank you so much for being fabulous so far. So this next question comes in and says, "What if we remove the agency as part of this story? Should we still ensure that we have in the contract that we use AI to edit the images?" So Caitlin says platforms like Canva, for example, have made life super easy to change the background on images. So Caitlin worries it's becoming too easy to slip up there, which is a really great point.
Yeah, and look, I think the law here in the UK is certainly coming. It's the government have got quite a tricky task ahead of them, because the EU have brought in the EU AI Act, which demands transparency
Mm-hmm.
around AI use. You have to disclose it if you're deploying AI systems across the EU, and they take a risk-based approach. I won't bore you with the complexity of the EU AI Act, because it's quite a tricky piece of legislation. It's far-reaching. UK doesn't want to implement that approach because it recognises that if you introduce too much red tape, you're not going to get innovation, and you're not going to get progress, and you're not going to get investment into this country, which we desperately need. So I think the UK is a great place to be dealing with AI at the moment, but you do have good old fashioned data protection principles, current IP legislation, and contract law to be really mindful of. And
Mm-hmm.
to Caitlin's point around Canva, obviously utilizing AI now for obviously some of the creative output with the work that she's doing. My view on that would be, I think it's better to be clear. And oh, sorry, sound quality has dipped. I'm hoping some people can still hear me. But
We've still got you. It's like it's a little bit tinny, but like we can still hear your voice, mate. So
okay, good. Apologies. Hopefully, it'll improve in a moment. But yeah, my view on that would be I would disclose AI use, have it covered off in your contracts.
Mhm.
Because I think it's a third party tool that you're using, and AI brings in an element of unknown with how it's operating.
Mhm.
And I think that really you should be covering off in your contract just to hedge your risk. And it's best really that, I mean, when you have to get a contract out, it's quite the relationship strained. The
Yeah.
beauty is the contract gives you confidence. The
Hmm.
conversation is where the art of the relationship is. And I think,
Totally.
at the outset, have the conversation with your client about how you're using AI.
Love that, mate. Thank you very much. That's really, really solid. And I love it's an important point to make the difference between a contract and a conversation. That's really, really helpful. So thank you.
No worries.
Um, let's move into the second story, the second topic, because we've spoken a reasonable amount about contracting already so far. But one of the things that I think we're seeing a lot of folks using AI for is writing contracts and so on and so forth. So I don't actually know if there's a story associated with this or whether this is a general watch out, but I'd love.
There, there is. It's a general watch out based on another true story. Which so the overview here is be careful when it comes to using AI to draft your contracts and your policies. Um, I mean, look, there's a famous example. They didn't draft a contract here, but they did charge a fortune to the Australian government for a bit of research and a document which was, I think the amount of money they had to refund was around about 400,000 Australian dollars, something like that, and that was Deloitte. So Deloitte fell foul of that. If you Google Deloitte ChatGPT Australian government, you'll find lots of news stories about their slip up with relying on AI for a very important gig.
Mhm.
What we're seeing from oh, that was their own AI that fell foul. Ah, well, there we are. That's probably even worse, isn't it? But where we're seeing some issues from a legal perspective, not only are the UK courts seeing problems with hallucinated cases being referenced, but on a more micro level, when we're looking at different businesses coming to us for legal challenges, we saw an introducer agreement that the client had used to prepare on AI. So they prompted ChatGPT in this case along the words to the effect of, please create me a referral agreement which will pay 10% commission for new business opportunities. And of
Mhm.
course, AI is eager to please. So straight off the bat of that first prompt, it was like, yeah, absolutely, Joe. What a great idea. Let me create you a referral agreement. Here it is. Look how good it is.
Yeah.
And of course, you look at it and think, wow, that's really impressive. It sounds really plausible. It
Mm.
saved me a fortune in legal fees. Let's use that. And obviously, this client had a little bit of a gut instinct and contacted us and said, look, cards on the table. We've used ChatGPT to create this, but we're just curious. Can you review it and let us know if there's any issues?
Mhm.
And we had a look at it, and the wording was lovely in terms of it was nice and easy to use, but the issue was context and the fact that what ChatGPT hadn't done was actually stop after the first prompt and say, okay, Joe, I can create you that, but first I'm going to need to ask you a little bit more information.
Mm.
What qualifies as a sensible referred piece of business? What does that look like? And what about if you already know that business, if they're already in your community? And what about if, let's say, they're not in your community and we refer them to you, but what if they don't pay you? What do
Mm.
you want to do with your introducer there? The contract that ChatGPT had created was essentially going to pay this particular referral commission, regardless of whether the opportunity is converted or not, and regardless
Mm.
of whether they were already known to the business or not. So again, while some people might be cool with that, actually in this instance, the client was absolutely not cool with that. They wanted to ensure that they were not paying commission until there was cash in the bank. And then at that point, they would pay commission, and they did not want to pay commission on opportunities that they were already aware of, which again, AI missed. So I think if you know how to prompt it, if you know what you're doing, you're probably going to get some really good outputs. But I would say that, a bit like me trying to create a snazzy marketing campaign, it's, sound is really weak. Hopefully,
I think you're right. If you lean forward, mate, I think it seems to be slightly better when you're leaning forward for some
oh,
reason.
okay. There we go. Hopefully, sorry. Hopefully, this is better. But it's a bit like me trying to use AI to create a really clever marketing campaign.
Yeah.
Oh, that much better. Thank you, Anne Marie. There we go. Oh, sorry about that, everyone. I'm going to stay leaning forward now so you can hear me. Sorry, thank you for bearing with me. There we go. Um, the point I was going to make is, of course, you can use AI to have a go at drafting your contracts. If you're bootstrapping, I think, look, crack on and get a lawyer to sense check it. But I
Mhm.
think, much like me trying to do a marketing campaign using AI, of course I can do it. But do I want to do it? No, because I'm not the expert in that area. My view is pay the experts to do what they do best. And if they're going to use AI to work more efficiently, great. But obviously, it's just raising awareness of some of the legal risks around doing that, which hopefully some of these stories are helping people understand. But
Yeah.
I know the next story you're going to ask me will hopefully be another good one to raise awareness on confidentiality.
Mate, you've teed it up perfectly. I don't even need to ask the question. You go for it.
So this one does worry me, and again, it's another one that you can easily sleepwalk into. And I think the overarching theme here is the disconnect between leadership teams and the overall business, the staff that are doing the really hard work day to day, that haven't been trained on what AI tools can be used in the business and what AI tools can't be used. And most importantly, why? Having a clear explanation as to why, that we're seeing as a real problem, because what that's creating is an environment where team members are just plugging in third-party AI tools without the leadership team's knowledge. And some of
Mhm.
those tools are swallowing up either personal data or sensitive client data or company data that is being used to train the wider models. For example, note takers are prolific at that. There's a note taker called Granola as one example, and there's a number of others where I've seen businesses use them in the background in a client meeting, and it's taken commercially sensitive information, created a transcript, and if you read the end user license agreement, based on the tier of license that the client is on, they're essentially opting into that conversation transcript being used to train the
Mhm.
wider model. So again, checking licenses is really key. But going back to the story and a real live example, start of this year, I received a phone call from an agency that looks after the healthcare industry. They were very, very worried because they've been put on notice by their, oh, yes, to LinkedIn settings as well. It's a good one, Richard. Thank you. But the agency had been put on notice by the client's legal team that there was a suspected breach of confidence. And they were quite friendly because there was a long-standing relationship. So the legal team, I think, were actually very good given the circumstances, because the legal team said, look, being open, we cannot rule out whether this is an internal breach or whether it's an external breach, but just know that you are the only external party. So stay tuned whilst we carry out this investigation, but we suggest that you carry out your own investigation as well. And what they were investigating was essentially they had used the agency to take a white paper that they had spent a very long time preparing, which contained useful data and statistics. And they wanted that agency to take that data to review the white paper and create a really engaging social media campaign to coincide with a product launch. And the timing of it from a market perspective was really key. And it's a listed company as
Mhm.
well. So high risk, and hence in-house legal team, general counsel, so on and so forth. And the contract made it very clear with the agency that AI was not to be used. And anyway, campaign clearly marked as confidential. It transpired that in the output data of ChatGPT, there were traces of this white paper and key slogans and catchphrases that were appearing in the outputs, where it was quite clear that somebody had uploaded the white paper into ChatGPT, clearly on a license that was enabling the wider training of the model.
Mhm.
And when we spoke to the agency, that was obviously quite distressed, one of our key questions was, tell us about the team working on that campaign and what AI tools they have access to. And it wasn't a clear answer. The short answer was, we don't know. And then we focused on ChatGPT, and the question was, well, what license do you have in place for ChatGPT? To which the answer was, we don't have a license. To which the next question was, well, is it fair to assume that your team members are perhaps using their own personal licenses for company work? Have you done any training, or have you taken any technical steps to kind of prevent that from happening? The answer was no, we haven't. And essentially, it's very clear that one of their team members had indeed used ChatGPT for that project. That's now an insurance matter. And it's a massive reputational issue. So that's how easy it is. Yes, AI is brilliant and it can be used, but it's very easy to actually put a step wrong. So I think, and it's easy to avoid it as well, because I think the golden rule there is really be clear with what your client expectations are, particularly if you're dealing with big brands that are risk averse, that go by the contract, that will have legal teams that care about this stuff. Because I think quite a lot of agencies will be working with businesses that perhaps don't care about this stuff at the moment. If you're dealing with an industry that's regulated or a company that's listed, where you know that this is a risk averse business and you're particularly signing up to their contract, make sure you're really familiar with what that contract is saying. And if there is anything that's talking about AI, IP, confidentiality, make sure your team are well and truly briefed on that, because it wasn't the employee's fault. The employee was not trained. They didn't have the right training. There was no comms about it, so they weren't going to lose their job. Couldn't class it as a disciplinary or any form of misconduct because there was no training. But the learn there for all of us is just really make sure that all of your team are on the same page with what AI tools you are using as an organization, making sure you're risk assessing them, read the end user license agreement, see what's being used for training, see what isn't, and just make sure that your internal policy is drafted only after you've done your risk assessment. And I always say, do an amnesty with your team. Yep. Tell them, burp up everything that you were using. Better the devil you know. And it is amazing what different tools we have seen over the last few months. I mean, there's over 40,000 of them and growing. So there's lots out there with all weird and wonderful names with different features. The ones that make me really nervous are the ones that plug into email. I think if you're plugging in AI to your email, that really, really worries me, because that is just hoovering up personal data and confidential data as well. So my personal practical tip would be, I would avoid email in terms of plugging AI into email at this stage. If you're going to do it, really, really risk assess it. Copilot, maybe. But again, go into it eyes wide open.
Nice. I love that. Thank you very, very much, mate. I really appreciate that. And Richard has asked a quick question here, which is, even Gemini, I don't want to sort of end up going too far into each platform, but is there a general rule of thumb that exists in your mind? And it's fine if the answer is no, by the way, that like a bigger, more established company is less likely to sort of no. Okay, judging by your face alone.
No, sadly not. I mean, look at what LinkedIn's recently done. I think somebody messaged on the chat that you actually have to proactively turn off in your data privacy settings a setting which has currently opted you in to training the LinkedIn model, taking your data to train its AI model. You physically have to switch that off. At the moment, there is a presumption that you're cool with that. And some people will be. I've met a number of people that they're like, take my data. I don't care. They can know anything and everything about me. Yeah. And then you think, oh, okay, you've just had a cyber attack and now you're the victim of fraud. How do you feel about that? Do you want everyone now to know your data? Probably not. But I get it. It's a fine balance, isn't it? Because we want to use the technology. And for me, it would be an absolute dream to plug it into my email, because, that would help, make my quality of life much better with, managing my inbox. But nevertheless, I value my clients and my contacts' personal data much more than I do efficiency with AI at this stage.
Nice.
I'm waiting really for the law and AI to get to a stage where we can really rely on it to process our personal data because it can be trusted, and there's a proven model there that can be trusted. That's what I'm personally waiting for. But to Richard's point around what about Gemini, for example? Well, I can't speak for Gemini, but what I can tell you is about a month and a half, 2 months ago, Malwarebytes released a statement. If some people on here may have heard of Malwarebytes, but I remember reading this on the Malwarebytes website. They're a cybersecurity specialist, and they were talking about a data breach with ChatGPT, an agent on ChatGPT, a form of agentic AI, where it's gone a step further than generative. This is now completely autonomous. You give it an instruction and off it goes. It's going to act on that instruction using its own autonomy. It plugged this research agent into its Gmail account, and it's reading through its emails on Gmail, and a cyber attacker has sent an email out of chance with white text on the email containing a malicious link. And of course, the agent clicks on it, opens the trapdoor, cyber attacker is now in, gets everything it needs to get. And ChatGPT, or rather OpenAI, jumped on that breach within, I think they jumped on it very, very quickly because they knew that that is just a reputational disaster if that spreads like wildfire. So they've plugged it, but it gives you an idea of, when you start plugging in tools to email, just personally, I just wouldn't do it. But if you are going to do it, just be prepared for the risk that is attached to it. That's my personal view.
Thank you, mate. That's so solid, and I love how you've linked issue to solution here. So thank you very much, mate. It's exactly what we want to do. So we've got 14 minutes left, and we've got 21 open questions, which
wow.
is just to summarize what we've spoken about in today's session so far. So hopefully, folks sort of feel good about what we've taken away already today. We've spoken around contracts and sort of making sure that they're done appropriately and checked appropriately. We've spoken about intellectual property with the example of the photographer, and we've spoken about the disconnect between senior management and the workforce in terms of knowing what to do. So there's some super practical stuff there. So super appreciate that so far, mate.
Pleasure.
We've got these open questions. It would be great to approach these as quick fire as we can, I guess, to make sure we get to as many as we can. So
I'll try my best. And if there's some that I need to take offline, the best bet will be if that person that's asked the question that I have to take offline, if they just send me an email, because I don't have their email address, if they send me an email, which is ryan.lisk@hybridlegal.co.uk, I will do my best to come back to you with an answer free of charge. There it is, because it's not technically advice, so very happy to answer it if I can.
That's lovely, mate. Thank you so much. And I just wanted to highlight your LinkedIn as well. So the QR code on screen there goes to your LinkedIn as well. So
thank you.
Hopefully,
I love the little avatar you've created for me there. That's very cool. My daughter would like to see that, I'm
sure. I'll send it across. So let's go into the Q&A. So we've got Adam asking a great question. So Adam says, if I ask an AI tool to collect some data for me, can I trust that it's going to search public domain and not acquire it in a non-compliant way?
Oh, good question. That I was very tempted to say, well, it depends. It does depend in a way. So just so I've understood the question, using an AI tool to scrape data, that data, what data is it? Is it personal data or is it non-personal data? Because I think if it's scraping personal data, that's a challenge, because what you're relying on there is I think what you've got to think about is, if I've scraped data using this AI tool, and Joe from Marketing Meetup is one of the individuals that's appeared on that list, and Joe now knocks my door and says, "Hey Ryan, I'd just like to know, how have you got my personal data?" If I then turn around and say to Joe, "Oh, I use this AI tool which scrapes it, but I can't tell you where it scrapes it from, I'm afraid,"
Mm,
That's not ideal from Joe's perspective because Joe's thinking, oh, great, I've got a legal right here, which is a right to be forgotten, a
mhm,
right to request Ryan to erase my personal data. That's my right under the Data Protection Act of 2018 and GDPR. But he can't adequately tell me where he's got the data from.
mhm,
That's a problem. And usually, obviously, when you buy data, you would usually have organizations like Credit Safe, for example, that will have a license to the data because they have an audit trail. They can give you a guarantee that the data that we sell you is opted in data. We've got an audit trail where Joe has consented that he's happy for me to share his information with interested third parties, and here's
mhm,
the trail. If you can't say to any individual that knocks your door, here's the audit trail of how you arrived on the database, and you
mhm,
opted in at this point to say you were happy for third parties to have your data, and that's how I've got it. I would say it's too high risk at the moment, not only from a legal perspective, but from a reputational perspective.
mhm.
I had one the other day, somebody cold called me on my personal mobile, and I said to him, look, as lovely as this is, do you mind telling me where you got my mobile number from? And he said, yeah, no problem. I got it from a system called Lusher. And I was like, oh, okay, great. Never heard of them. So my next target is Lusher to start interrogating where did you get my mobile number from? And I want it taken off ASAP. Thank you very much. So
And
yeah,
very quickly, and I don't know whether this is uh, any question is able to be answered quickly, but if it's not personally identifiable information, but say, for example, with the example that we gave with the confidentiality around the white paper earlier, if you're not able to point to the same audit trail in terms of like company data and stuff like that, are we speaking about the same things, or is that a different area of law when it describes not the personal data but more sort of corporate data and so
I
on?
think, yeah, I see where you're going with that. I think so. Park personally identifiable information to one side. Obviously, that's red hot.
Yeah.
Park that with company data that's publicly available. It is fair game,
Mhm.
but I would say that go careful if you're deploying any form of scraping tool on the internet, because if you are scraping, just be aware that more and more companies now are putting in their terms of use
Mhm.
that you are not allowed to deploy any form of AI to scrape the data on the website, regardless of it being personal or public, but usually public company data without prior permission.
Right.
So you look at the TripAdvisor website terms of use, for example, and you will find in TripAdvisor's website terms of use, there is now an AI clause there to prevent AI scraping tools. Mumsnet have got this very issue against OpenAI. They're one of the first UK companies to take legal action against OpenAI for just scraping and swallowing up all the data. And there is an old school piece of legislation called the Computer Misuse Act, dating right back to 1999, that actually makes it a criminal offence to knowingly deploy a computer to start scraping data without permission. And of course, the police aren't really going to care much about that, but there is such a thing as a private prosecution. With a private prosecution, an interested party will be news and media outlets that really want to actually control who doesn't use their content. So I think, I mean, watch this space with that piece of legislation. But as I say, the law is evolving, and it's going to be interesting to see how it shapes up. But I would just personally, I'd approach a course in what you scrape.
Nice. I love that. And thank you for speaking to that, mate. There's the top two questions. I've kind of spoken a little bit to what we've spoken about so far. I'm going to read them both if that's okay, because we
Yeah.
can hopefully answer them at the same time. So Montse has asked, Adobe is promoting their sorry, I'm actually I'm going to go back because a question's disappeared from my screen. So first, from Victoria, as a photographer slash videographer, is there a specific terminology you need to include in your contract with the client in order to protect yourself from AI editing, or are you covered due to general IP terms? And I think the reason why this is interesting is I think it could probably relate to what you've been speaking about in the terms of
Yeah.
service, in the AI clause that you were speaking about.
Yeah.
The other question was from James, who asked, "How can we protect ourselves in a similar way?"
Yeah, so the first question around photography, stroke videography, and having some wording in a contract to guard against AI use. I mean, look, the good news is if you don't have a contract in place with your client and you are the rights creator, the rights
Mhm.
holder, so you are the photographer, the original photographer or the original videographer, and there is no contract, and your client does go on to plug it into AI and modify it, you have a route to claim there because they're modifying without your permission and they don't own the IP. So they're using something that they don't own.
Mm.
However, reality is best to be transparent, best to be really clear with who you're dealing with. So I would argue that have a contract in place which spells out what you're doing with your IP, and it also spells out what your expectations are with AI. Because you might think that actually you this lends itself to a different pricing structure for your business, because you might think that actually for just access to the content for a certain period of time, so a license to the content, you pay this. If you want ownership to it, you pay this. Or you might think actually if you want to use it with AI, then this is the price you pay. So you are in the driving seat in that regard, but the contract will underpin that. So.
Love that. That's great, mate. Thank you. I love that you're bringing that into business models as well. That's really smart. So appreciate that. I guess that's a founder speaking as well. So
Yeah.
let's go to the question from Monse because it has gravitated to the top. So Adobe is promoting their AI functionality as a very safe solution when it comes to generating images and videos, etc., free from IP issues. They've just asked for your opinion on this, and like, I think I'm actually a bit careful about like sort of picking out specific companies, etc. But when it comes to companies advertising imagery or etc. from IP issues, what's your general opinion? Is that something that can sit within these companies' wheelhouse?
Wow, what I would be doing, and yeah, I have heard of actually Adobe making really good progress with obviously how they're using AI, how they've trained their model because they've spotted the issues with OpenAI. Obviously,
Mhm.
Getty Images have got a major issue with OpenAI at the moment, and I think they've been on the money with how they've developed their own AI system, taking stock of what's been going on there. But would I trust it? I think what I would do is I'd have a look to see how they're managing liability. So I would be looking at what does their license agreement say in the event that something is produced from their system that is found to contain third-party unlicensed IP. See what the liability says, because you'll find that in quite a lot of these end user license agreements, there will be a nice disclaimer to say, look, I know in our marketing we say that it's all really nice and fuzzy and it's clean, but we've got some disclaimers here that you need to be aware of. So if it does go south, we're not liable. If we are, it's $100.
Mhm.
So I think it's looking at risk. Make sure that's reflected in your contract with the end client. So pass the risk down the chain rather than you being left with that liability. If you have relied on Adobe and Adobe is wrong, sadly, they're just going to send you their end user license agreement and say, sorry, we're not liable.
Mhm. Mhm.
Make sure that that's passed down the chain with your contract with your client, if you are going to do that. That's where I think the risk is worth it if you can hedge it with your contracts.
Love that so much. Mate, it's been very close to the full hour now, and like I can see the open questions, and it's burning me a little bit because like I know that there's so much more that we can give, but we promise an hour and we deliver an hour. I probably just want to prompt you. We spoke about three main issues today. We spoke about that senior team alignment. We spoke about contracts, and we spoke about IP. If you were to do three things that folks could do in three sentences on each of these sort of tasks, where would your sort of takeaways be for today's session?
AI amnesty with your team ASAP.
Mm-hmm.
Work out what you are currently using. Have eyes on that. then risk assess it. I know it's boring, but read the end user license agreements, see what's going on with data, with training. Are you on the right license? And then create your internal policy and your external client policy. Once you've done your thinking there, check your data protection as well. Make sure you're compliant there. Contracts, really key. Make sure your client contract covers you with AI and it's nice and clear. Make sure you button up your freelancers as well if you're using any subcontractors. Close those two chains. That's what I would do. And sanitize your data. Don't put personal data in. Don't put confidential data in. Sanitize it, anonymize it if you have to. But I would encourage you to use AI. I think it's going to be great. So yeah, hopefully that helps. I'm available on LinkedIn or drop me a message. Any questions? Always happy to help.
You're a good man. Thank you, Ryan. And like, you know, you were sweet earlier on because you sort of said I don't want to pitch myself. Like as a client of yours, I'm happy to sort of advocate for you as well, mate. You know, so thank you. And there's so many lovely comments coming in from the community. So thank you all so much for your questions as well. And
yeah, thank you very much.
Truly brilliant. So thank you, everyone. The overwhelmingly wonderful on screen right now with those those reactions. So thank you for that. I hope you have a lovely week, everyone. We will be back very soon with our next webinar. I don't know whether it'll be next week or the week after or the week after that. We've got some moving parts coming in, but we'll communicate it very soon. In the meantime, just a big thank you to Frontify, who are the key sponsor for today. Bring all your digital assets into one place. They're fabulous. Also, a big thank you to Wistia, Planable, Known, and Cambridge Marketing College. You're all wonderful companies. You're wonderful people for tuning in. Thank you very much. And I hope you have a lovely afternoon. Ryan, you're a legend, mate.
Take care. Pleasure. Thank you very much for having me.
No worries. See you soon.